Ethics and bioethics. Ethics involves determining the best course of action in a certain situation. Ethical reasoning is the analysis of what is morally right and reasonable. Bioethics is the application of ethics to healthcare. Ethical behavior for nurses is discussed in codes such as the ANA Code of Ethics for Nurses with interpretive statements. Ethical issues have become more complex as technology has created more options in healthcare. These issues are controversial because agreement over what is right or best does not exist, and because moral support is possible for more than one course of action. Ethical dilemmas. An ethical dilemma is a situation in which no solution is completely satisfactory. Opposing courses of action may seem equally desirable, or all possible solutions may seem undesirable. Ethical dilemmas are among the most difficult situations in nursing practice. To find solutions, nurses and other healthcare personnel should apply ethical theories and principles and determine the burdens and benefits of any course of action. Ethical theories. 3 models guide ethical decision-making: deontologic, utilitarian, and human rights. Few people use one decision-making model exclusively. Instead, they make decisions by examining models and determining which is most appropriate for the circumstances. Deontologic model. The deontologic model determines what is right by applying ethical principles and moral rules. It does not vary the solution according to individual situations. One example is the rule, life must be maintained at all costs and in all circumstances. Strictly used, the deontologic model would not consider the quality of life or weigh the use of scarce resources against the likelihood a life maintained would be near normal. Utilitarian model. The utilitarian model approaches ethical dilemmas by analyzing the benefits and burdens of any course of action to find one that will result in the greatest amount of good. Appropriate actions may vary with the situation when using the utilitarian model. The utilitarian approach is concerned more with the consequences of actions than the actions themselves. In its simplest form, the utilitarian approach is the end justifies the means. If the outcome is positive, the method of arriving at the outcome is less important. Human rights model. The belief that each person has human rights is the basis for the human rights model to making ethical decisions. The nurse may find personal difficulty in the right of a person to refuse care that the nurse and possibly other care providers believe is best. A nurse's goal is usually to save lives. But what if the person's life is intolerable or care is refused? Ethical principles. Ethical principles or rules are also important for solving ethical dilemmas. 4 of the most important principles are beneficence, non-maleficence, respect for autonomy, and justice. Other important ethical principles, such as accountability, confidentiality, truth, and keeping promises, are derived from these 4 basic principles. Box 2.3, Ethical Principles in Healthcare. Autonomy. People have the right to self-determination. This includes the right to respect, privacy, and information necessary to keep decisions based on their personal values and beliefs. Beneficence. Make a decision that produces greatest good or the least harm. Non-maleficence. Avoid risking or causing harm to others. Justice. All people should be treated equally and fairly, regardless of disease or social or economic status. Fidelity. Keep promises and do not make promises that cannot be kept. Truth. Veracity. Tell the truth. Confidentiality. Keep information private. Accountability. Accept responsibility for actions as a healthcare professional. These principles guide decision-making, but in some situations, the application of one principle conflicts with another. In such cases, one principle may outweigh another in importance. Treatments designed to do good also may cause harm. For example, cesarean birth may prevent permanent harm to a fetus in jeopardy. However, the surgery that saves the fetus also harms the mother, causing pain, temporary disability, and possible financial hardship. Also, certain basic surgical risks to the mother do exist. Both the mother and the healthcare providers may decide the principle of beneficence outweighs the principle of non-maleficence. If the mother does not want surgery, the principles of autonomy and justice also should be considered. Is the mother's right to determine what happens to her body more or less important than the right of the fetus to fair and equal treatment? Solving dilemmas in daily practice. Nurses are often involved in supporting parents when tragedy strikes during a birth. They should be knowledgeable regarding the disease process and the appropriate nursing care in these situations, and also be able to support families' needs when ethical dilemmas arise. However, ethical challenges often arise during day-to-day professional practice. Nurses and other professionals should learn to analyze and resolve these dilemmas. Personal values and cultural and language differences are some of the issues that often have an impact on the solving of ethical dilemmas. Ethical dilemmas, a situation in which no solution seems completely satisfactory, also may have legal ramifications. For example, although the American Medical Association has stated anencephalic organ donation is ethically permissible, it may be illegal. In many states, the legal criteria for death include cardiopulmonary as well as brain death. Therefore, donor organs from the baby with anencephaly are likely unusable for transplantation because of lengthy anoxia. I'm going to insert a definition of anencephaly for reference here from Wikipedia. Anencephaly is the absence of a major portion of the brain, skull, and scalp that occurs during embryonic development. It is a cephalic disorder that results from a neural tube defect that occurs when the rostral head end of the neural tube fails to close, usually between the 23rd and 26th day following conception. So now I'm remembering it's usually those heartbreaking images you see of a baby with just a very large swollen head. So that's a disability there. Greater understanding about conflicts and misunderstandings that may arise from the differences among people helps nurses find better solutions to ethical dilemmas and other problems common to daily life. Many approaches can be used to solve ethical dilemmas in nursing practice. No single approach guarantees a right decision, but it provides a logical, systematic method for decision making. Because the nursing process is also a method of problem solving, nurses can use a similar approach when faced with ethical dilemmas. Box 2.4. Decision making in ethical dilemmas may seem straightforward, but it rarely results in answers acceptable to everyone. Healthcare agencies often have bioethics committees to formulate policies for ethical situations, provide education, and help make decisions in specific cases. The committees include a variety of professionals, such as nurses, physicians, social workers, ethicists, and clergy members. The family members, most closely affected by the decision, also participate if possible. A satisfactory solution to ethical dilemmas is more likely to occur when people work together. Ethical issues in reproduction. Many issues cross the boundary between ethics and legality and apply to all caregivers. These issues apply to many fields of care, including reproduction and women's health. Reproduction issues often involve conflicts in which a woman's behaviors may cause harm to her fetus and be disliked by some or most members of society. Conflicts between a mother and fetus occur when the mother's needs, behaviors, or wishes may injure the fetus. The most obvious instances involve abortion, substance abuse, and a mother's refusal to follow the advice of caregivers. Healthcare workers and society may respond to such a woman with anger rather than support. However, the rights of both the mother and fetus should be examined. Elective pregnancy termination. Abortion, or elective termination of pregnancy, was a volatile legal, social, and political issue even before the Roe v. Wade decision by the U.S. Supreme Court in 1973. Before then, states could outlaw abortion within their boundaries. In Roe v. Wade, the Supreme Court stated abortion was legal in the United States and existing state laws prohibiting abortion were unconstitutional because they interfered with the mother's constitutional right to privacy. This decision stipulated, 1, a woman could obtain an abortion at any time during the first trimester. 2, the state could regulate abortions during the second trimester only to protect the woman's health. And 3, the state could regulate or prohibit abortion during the third trimester except when the mother's life might be jeopardized by continuing the pregnancy. Since 1973, many state laws have been upheld or rejected by Supreme Court decisions. Some people believe abortion should be illegal at any time because it deprives the fetus of life. In contrast, others believe women have the right to control their reproductive functions, and political discussion of reproductive rights is an invasion of the woman's most private decisions. For many people, the woman's constitutional right to privacy conflicts with the right to life of the fetus. However, the Supreme Court did not rule on when life begins. This omission provokes debate between those who think life begins at conception and those who think life begins when the fetus is viable or capable of living outside the uterus. Those who think life begins at conception may be opposed to abortion at any time during pregnancy. Those who think that life begins when the fetus is viable, 20 to 24 weeks of gestation, may oppose abortion after that time. Nurses need to understand abortion laws and the conflicting beliefs that divide society on this issue. Implications for nurses. Nurses' responsibilities in the conflict about abortion cannot be ignored. First, they should be informed about the complexity of the abortion issue from legal and ethical standpoints and know the regulations and laws in their state. Second, they should realize that for many people, abortion is an ethical dilemma resulting in confusion, ambivalence, and personal distress. Next, they should also recognize that for many others, the issue is not a dilemma, but a fundamental violation of the personal or religious views that give meaning to their lives. Finally, nurses should acknowledge the sincere convictions and strong emotions of those on all sides of the issue, including themselves. Professional obligations. Nurses have no obligation to support a position with which they disagree. The Nursing Practice Acts of many states allow nurses to refuse to assist with a procedure if it violates their ethical, moral, or religious beliefs. However, nurses are obligated to disclose this information before they are employed in an institution where abortions are performed. It is unethical for a nurse to withhold this information until assigned to care for a woman having an abortion and then refuse to provide care. As always, nurses should respect the decisions of women who look to nurses for care. If nurses think they are not able to provide compassionate care because of personal convictions, they should inform a supervisor so appropriate care can be arranged. Mandated contraception. The availability of contraception that does not require taking regular oral dose, such as using a hormone-releasing patch or having hormone injections or an intrauterine device, IUD, has led to speculation about whether certain women should be forced to use this method of birth control. Requiring contraception has been used as a condition of probation, allowing women accused of child abuse to avoid jail terms. Some people think mandated contraception is a reasonable way to prevent additional births in the case of women who are considered unsuitable parents and to reduce government expenses for dependent children. A punitive approach to social problems does not provide long-term solutions. Requiring poor women to use contraception to limit the money spent on supporting them is legally and ethically questionable and does not address the obligations of the children's father. Such a practice interferes with a woman's constitutional rights to privacy, reproduction, refusal of medical treatment, and freedom from cruel and unusual punishment. In addition, medication may pose health risks to the woman. Surgical sterilization, tubal ligation, also carries risks and should be considered permanent. Access to free or low-cost information on family planning would be more appropriate and ethical. Fetal injury. If a mother's actions cause injury to her fetus, the question of whether she should be restrained or prosecuted has legal and ethical implications. In some instances, courts have issued jail sentences to women who have caused or who may cause injury to the fetus. This response punishes the woman and places her in a situation in which she cannot further harm the fetus. In other cases, women have been forced to undergo cesarean births against their will when physicians have testified such a procedure was necessary to prevent injury to the fetus. The state has an interest in protecting children, and the U.S. Supreme Court has ruled a child has the right to begin life with a sound mind and body. Many state laws require evidence of prenatal drug exposure be reported. Women have been charged with negligence, involuntary manslaughter, delivery of drugs to a minor, and child endangerment. However, forcing a woman to behave in a certain way because she is pregnant violates the principle of autonomy, self-determination of competent adults, bodily integrity, and personal freedom. Because of fear of prosecution, this practice could impede, not advance, health care during pregnancy. The punitive approach to fetal injury also raises the question of how much control the government should have over a pregnant woman. Laws could be passed to mandate maternal HIV testing with no right to refuse, fetal testing, intrauterine surgery, or even the foods the woman eats during pregnancy. The decision with regard to just how much control should be allowed in the interests of fetal safety is difficult. Fetal therapy. Fetal therapy is becoming more common as techniques improve and knowledge grows. Although intrauterine blood transfusions are relatively standard practice in some areas, fetal surgery is still relatively uncommon. The risks and benefits of surgery for major fetal anomalies should be considered in every case. Even when surgery is successful, the fetus may not survive, may have other serious problems, or may be born severely preterm. The mother may require weeks of bed rest and a cesarean birth, yet despite the risks, successful fetal surgery may result in birth of an infant who could not otherwise have survived. Parents need help to balance the potential risks to mother and the best interests of the fetus. They might feel pressured to have surgery or other fetal treatment they do not understand. As with any situation involving informed consent, women need adequate information before making a decision. They should understand if procedures are still experimental, the known chances of a procedure's success, and if any alternative treatments are available and their chances of success. Issues in infertility. Infertility treatment. Perinatal technology has found ways for some previously infertile couples to bear children. See Chapter 26. Many techniques are more successful, but ethical concerns include the high cost and overall low success of some infertility treatments. Because many of these costs are not insured, their use is limited to the affluent. Techniques may benefit only a small percentage of infertile couples. Despite treatment, many couples never give birth, regardless of the costs or invasiveness of therapy. Successful treatment may lead to multiple gestations and complications related to maternal age. Other ethical concerns focus on the fate of unused embryos. Should they be frozen for later use by the woman or someone else or used in genetic research? What if the parents divorce or die? Who should make these decisions? In multiple pregnancies, with more fetuses than can be expected to survive intact, reduction surgery may be used to destroy one or more fetuses for the benefit of those remaining. The ethical and long-term psychological implications of this procedure are also controversial. Assisted reproductive techniques now allow postmenopausal women to become pregnant. What are the ethical implications of conceiving and giving birth to children whose mother is several decades older than their friends' mothers and is more likely to die when the children are relatively young. Should the age and health of the parents be a factor in determining whether this treatment is offered? Should a consideration be the risk these women face for complications that might result in unhealthy infants? Should average life expectancy enter the decision? Surrogate parenting. In surrogate parenting, a woman agrees to bear an infant for another woman. Conception may take place outside the body using ova and sperm from the couple who wish to become parents. These embryos are then implanted into the surrogate mother. Or the surrogate mother may be inseminated artificially with sperm from the intended father. Donated embryos also may be implanted into a surrogate mother. Cases in which the surrogate mother has wanted to keep the child have created controversy. No standard regulations govern these cases, which are decided individually. Ethical concerns involve who should be a surrogate mother, what her role should be after birth, and who should make these decisions. Screening of parents and surrogates is necessary to determine whether they are suited for their roles. Who should perform the screening? Should it be left to the private interests of those involved, or should government become involved? An issue closely related to surrogate parenting is the use of donor gametes, or unused embryos, from another infertile couple. Will the use of donor gametes, or embryos, violate religious or moral beliefs of the parents? Does the child thus conceived have a right to know the identity of the biologic parents? What are the rights of the biologic parents? Privacy issues. Many people are concerned about the possible misuse of their health information. They may fear that health information is in the wrong hands. Whether that information is accurate or not may cost them a job, promotion, loan, or something equally valuable. Privacy concerns and fear of health care or other insurance loss may cause a person to withhold genetic or other medical history information from a provider. Quality of genetic counseling may be impaired if family members refuse to release their medical records. Government regulations. The Health Insurance Portability and Accountability Act, HIPAA, of 1996 was designed to reduce fraud in the insurance industry and make it easier for people to remain insured if they move from one job to another. Within HIPAA's provisions was the mandate for Congress to pass a law to protect the privacy of personal medical information by August 1999. Congress failed to do so, and the Secretary of the DHHS proposed interim regulations in October 1999 to protect personal medical privacy as required by HIPAA. The DHHS regulations provide consumers with significant new power over their records, including the right to see and correct their records, the application of civil and criminal penalties for violations of privacy standards, and protection against deliberate or inadvertent misuse or disclosure. See www.hhs.gov for additional information. Electronic communications. A person's health data are generally maintained in various computerized formats. Although this allows nearly instantaneous exchange of data among providers, it also may carry the potential for greater violation of privacy than data maintained on paper. Terminals may be placed in hallways or patient rooms to facilitate quick entry and retrieval of information for staff. The nurse should remember this information also may be easily accessed by a computer-savvy person despite the use of passcodes and other security measures. Nurses should take care to avoid violating patient confidentiality by promptly logging off terminals when finished and following facility protocols for protection of security passcodes. Social media sites allow nurses to exchange information and nursing care tips that can improve practice. These forums also have the potential to allow lapses of patient or institutional confidentiality because their communications cannot be considered private. When participating in discussion lists or using email, nurses should respect the confidentiality of patients, colleagues, and institutions. Institutional documents such as chart forms, policies, and procedures should not be shared without the facility's approval. A personal message should not be forwarded without the original sender's permission. The ANA and National Council for State Boards of Nursing provide resources for nursing regarding appropriate use of social media. Legal issues. The legal foundation for the practice of nursing provides safeguards for patients and sets standards by which nurses can be evaluated. Nurses need to understand how the law applies specifically to them. When nurses do not meet the standards expected, they may be held legally accountable. Safeguards for healthcare. 3 categories of safeguards determine the law's view of nursing practice. 1. Nurse Practice Acts. 2. Standards of care set by professional organizations. And 3. Rules and policies set by institutions employing the nurse. Nurse Practice Acts. The Nurse Practice Act of each state determines the scope of practice of registered nurses in that state. Nurse Practice Acts define what the nurse is allowed to do when caring for patients. The acts also specify what the nurse is expected to do when providing care. Some parts of the law may be very specific. Others are stated broadly to allow flexible interpretation of the role of nurses. Nurse Practice Acts vary across states, and nurses should understand these laws wherever they practice. Nurses should have a copy of the Nurse Practice Act for their state and refer to it for questions about their scope of practice. Most state nurse practice acts are available on the Internet. The website of the National Council of State Boards of Nurses, NCSBN, has information on nurse practice acts for all states, all territories, and the District of Columbia, as well as other information related to licensing and practice. Laws relating to nursing practice also delineate methods, called standard procedures or protocols, by which nurses may assume certain duties commonly considered part of medical practice. The procedures are written by committees of nurses, physicians, and administrators. They specify the nursing qualifications required for practicing the procedures, define the appropriate situations, and state the education required. Standard procedures allow the role of the nurse to change to meet the needs of the community and expanding knowledge. Standards of care. Court decisions have generally held that nurses should practice according to established standards and health agency policies in addition to nurse practice acts. Standards of care are set by professional associations and describe the level of care that can be expected from practitioners. For example, perinatal nurses are held to the national standards published by AHWAN, which are based on research and the agreement of experts. AHWAN also publishes practice resources, position statements, and other guidelines for nurses. Nurses should be familiar with the latest standards of care that cover their own practices. Agency policies. Each healthcare agency sets specific policies, procedures, and protocols governing nursing care. Nurses are frequently involved in writing and revising nursing policies and procedures. Policies and procedures increase staff adherence to professional, legal, and regulatory standards, statutes, and accreditation requirements, decrease variation in practice, and provide a reference for staff, decreasing dependence on memory, which can be a major source of human errors or oversights. In the event of a malpractice claim, the applicable policy, procedure, or protocol is likely to be used as evidence. The case of the professionals is strengthened if all agency policies are followed properly. These policies should be revised and updated regularly. Malpractice, limiting loss. Negligence is the failure to perform as a reasonable, prudent person of similar background would act in a similar situation. Negligence may consist of doing something that should not be done or failing to do something that should be done. Malpractice is negligence by professionals such as nurses and physicians in the performance of their duties. Nurses may be accused of malpractice if they do not perform according to established standards of care, and if the manner of a reasonable, prudent nurse with similar education and experience in a similar situation. 4 elements must be present to prove negligence: duty, breach of duty, damage, and proximate cause. Malpractice claims continue to be a major cost in healthcare. As a result of awards for such claims, the cost of malpractice insurance has risen for all healthcare workers. More healthcare workers practice defensively and accumulate evidence that their actions are in the patient's best interest. Many reasons exist for perinatal malpractice claims. Complications are usually unexpected because parents view pregnancy and birth as normal. The birth of a child without problem is a tragic shock, and parents may look for someone to blame. Although very small preterm infants may survive, some have long-term disabilities and require expensive care. Statutes of limitations vary across states, but plaintiffs often have more than 20 years to file lawsuits involving a newborn. Therefore, the period during which a malpractice suit may be filed is longer. Healthcare agencies and individual nurses should work together to prevent malpractice claims. Nurses are responsible and accountable for their own actions. Therefore, they should be aware of the limits of their knowledge and scope of practice, and they should practice within those limits. Prevention of claims is sometimes referred to as risk management or quality assurance. Although prevention of all malpractice claims is impossible, nurses can prevent malpractice judgments against themselves by following guidelines for informed consent, refusal of care, and documentation, acting as a patient advocate, and maintaining their levels of expertise. Informed consent. When patients receive adequate information, they are less likely to file malpractice suits. Informed consent is an ethical concept that has been enacted into law. Patients have the right to decide whether to accept or reject treatment options as part of their right to function autonomously. To make wise decisions, they need full information about treatments offered. Competence. Certain requirements should be met before consent is considered informed. First, the patient should be competent or able to think through a situation and make rational decisions. Infants, children, and patients who are comatose or severely cognitively impaired are incapable of making such decisions. A patient who has received drugs that impair the ability to think is temporarily incompetent. In these cases, another person is appointed to make decisions for the patient. In most states, the age of majority, the age at which a person can give consent to medical treatment, is 18 years. However, in some states, younger adolescents can consent independently to some treatments, such as those for mental illness, abortions, contraceptives, drug abuse, and STDs. An emancipated minor is younger than the age of majority, usually 18 years, and considered medically competent to make some medical decisions independent of a parent or guardian. Pregnant adolescents may be considered emancipated minors in some states. Nurses should be familiar with laws governing age of consent in their practice area. Another exception to the usual requirement of informed consent is in emergency circumstances. In such situations, consent is considered implied. Treatment may proceed if there is no evidence the patient does not want the treatment. Emergency may be specifically defined by state law and is usually restricted to unforeseen conditions that, if uncorrected, would result in severe disability or death. Emergency consent applies only for the emergency condition and does not extend to any other non-emergency problem that coexists with the emergency condition. Patient information about advance directives, such as a living will, durable power of attorney for healthcare, and an alternative decision maker for the patient, should be assessed on admission to the healthcare facility. Often, hospitals are required to inform patients about advance directives during the nursing admission assessment. The person who has not made advance directives should be offered the opportunity to make these choices. Full disclosure. The second requirement is full disclosure of information, including details of what the treatment entails, the expected results, and the meaning of those results. The risks, side effects, benefits, and other treatment options should be explained to patients. The person also should be informed about the consequences if no treatment is chosen. Understanding of information. The third requirement is that the person should comprehend information about proposed treatment. Healthcare professionals should explain the facts in terms the person can understand. If a patient does not speak English, an interpreter is required. A patient with hearing impairment should have a sign language interpreter of the appropriate level to sign all explanations before consent is given. Interpreters should not be family or friends because these people may interpret selectively rather than objectively. Additionally, patient confidentiality is compromised when non-professional interpreters are used for sensitive information. Nurses should be advocates for the patient when they find the patient does not fully understand or has questions about a treatment. If it is a minor point, the nurse may be able to explain it. Otherwise, the nurse should inform the physician of the need for clarification. Voluntary consent. The fourth requirement is that patients should be allowed to make choices voluntarily without the undue influence or coercion from others. Although others may give information, the patient alone makes the decision. Patients should not feel pressured to choose in a certain way, and they should not think their future care depends on their decision. Refusal of care. Occasionally, some persons decline treatment offered by healthcare workers. Patients refuse treatment when they think the benefits of treatment are insufficient to balance the burdens of the treatment of their quality of life after treatment. Patients have the right to refuse care, and they can withdraw agreement to treatment at any time. When a person makes this decision, a number of steps should be taken. If the provider is unaware of the patient's decision, the nurse should notify that provider and document the notification accordingly. There should be verification that the patient understands the treatment and consequences of refusal. Opinions by other providers may be offered to the patient. A description of the treatment refused should be documented in the patient's chart, as well as the explanations given to the patient and her refusal. Every effort should be made to obtain a written refusal from the patient indicating that she has been informed of the risks and benefits of the treatment and the refusal of the treatment. The nurse should refer to the facility's procedure for patient refusal of treatment for other requirements. If no ethical dilemma exists, the patient's decision stands. In cases of an ethical dilemma, a referral may be made to the Hospital Ethics Committee. In rare situations, the physician may seek a court ruling to force treatment. For example, when a woman refuses a cesarean birth, her decision may gravely harm the fetus. This situation is the only legal instance in which a person is forced to undergo surgery for the health of another. However, court action is avoided, if possible, because it places the woman and her caregiver in adversarial positions. In addition, it invades the woman's privacy and interferes with her autonomy and right to informed consent. If legally mandated surgery were to become widespread and cause women to avoid health care during pregnancy, the resulting harm would affect more women and infants than those who would be protected by the surgery. Coercion is illegal and unethical in obtaining consent. Even though the nurse may strongly think a woman should receive the treatment, she should not feel forced to submit to unwanted procedures. Nurses should not allow personal feelings to adversely affect the quality of their care. People have the right to good nursing care regardless of their decisions to accept or reject treatment. Documentation. Nurses are expected to meet the standard of care, or the level of care expected of a professional as determined by laws, professional organizations, and healthcare agencies. Documentation is essential for collaborative patient care and is also the best evidence that a standard of care has been maintained. It includes nurses' notes, fetal monitoring strips, electronic data, flow sheets, care paths, consent forms, and any other data recorded on paper, recorded electronically, or both. In many instances, notations in hospital records are not only proof care has been given. When documentation is not present, juries may assume that care was not given. Documentation should demonstrate through initial and ongoing assessments, identification of problems, interventions used, and evaluation of their effectiveness, as well as information reporting to other members of the healthcare team. Documenting discharge teaching. Discharge teaching is important to ensure patients know how to take care of themselves and their infants after they leave the facility. To prevent or defend against lawsuits, nurses should document the teaching they perform and the patient's understanding of that teaching. Various documentation forms verify teaching and the degree of understanding about important topics. The nurse also should note the need for reinforcement and the method of providing reinforcement. Documenting incidents. Another form of documentation used in risk management is the incident report, sometimes called a quality assurance report or variance report. The nurse completes a report when something occurs that might result in legal action. For example, injury to a patient, visitor, or staff member. The report alerts the agency's legal department that a problem may exist. It also identifies situations that might endanger patients in the future. Incident reports are not a part of the patient's chart and should not be referred to on the chart. When an incident occurs, documentation on the chart should include the same type of factual information about the patient's condition that would be recorded in any other situation. Late entries in documentation may be necessary after an emergency in which a nurse should provide patient care quickly. Late entries should be accurate and objective rather than defensive, especially if the outcome was negative in the entry. The nurse as patient advocate. Nurses are ethically and legally bound to act as a patient's advocate. When nurses think the patient's best interests are not being served, they are obligated to seek help from appropriate sources. This usually involves relaying the problem through the facility's chain of command. The nurse consults a supervisor and the patient's physician. If the results are not satisfactory, the nurse continues through administrative channels to the director of nurses, hospital administrator, and chief of the medical staff, if necessary. All nurses should know the chain of command process for their workplaces. Nurses should document their efforts to seek help for patients. For example, when postpartum patients are experiencing excessive bleeding, nurses document the methods used to control the bleeding. They also document each time they call the physician, the information given to the physician, and the response received. When nurses cannot contact the physician or do not receive adequate instructions, they should document their efforts to seek instruction from others such as a supervisor. Nurses should continue their efforts until the patient receives the care needed. Maintaining expertise. The nurse also can reduce malpractice liability by maintaining expertise. To ensure nurses maintain their expertise in provision of safe care, states require proof of continuing education for renewal of nursing licenses. Nursing knowledge grows and changes rapidly, and all nurses should keep current. New information from classes, conferences, and professional publications can help nurses perform as would a reasonably prudent peer. Nurses should analyze research articles to determine whether changes in patient care are indicated by the research evidence. Employers often provide continuing education classes for their nurses through conferences, satellite television systems, computer networks, and other means. Membership in professional organizations, such as state branches of the ANA, or in specialty organizations such as AHON, gives nurses access to new information through publications, nursing conferences, and other educational offerings. Continuing nursing education is also widely available on the internet. Expertise is a concern when nurses are floated or required to work with patients whose needs differ from those of the nurse's usual patients. A nurse may be floated from one maternal-newborn setting to another or to a non-maternity setting. In these situations, nurses need cross-training, which includes orientation and education to perform care safely in new areas. The employer should provide appropriate cross-training for nurses who float. Nurses who work outside their usual area of expertise should assess their own skills and avoid performing tasks or taking responsibilities in areas until they have been educated to be competent in those areas. Cost containment and downsizing. Measures to lower healthcare costs continue to directly and indirectly affect nurses' work. Two measures of special concern are the use of unlicensed assistive personnel and brief length of stay for patients. Delegation to unlicensed assistive personnel. Delegation of care to an unlicensed person may allow the nurse to focus on greater needs within the group of patients. Orientation and education of unlicensed assistive personnel should be completed and is competency-based in both initial training and ongoing evaluations. UAP should be identified to the patient as a non-licensed person. Nurses should be aware that they remain legally responsible for patient assessments and make the critical judgments necessary to ensure patient safety when delegating tasks to a UAP. Nurses should know the capabilities of each unlicensed person who is caring for patients and supervise them sufficiently to ensure competence. The ANA's Principles for Delegation by Registered Nurses to UAP and AHAN's The Role of Unlicensed Assistive Personnel in the Care of Women and Newborns help nurses understand their roles in working with UAP. Early discharge. Regardless of the patient's diagnosis, the time for admission to discharge is as short as possible to keep costs in check and to reduce chances for a hospital-acquired infection. Because birth is considered a normal event that does not require a long length of stay, care of new mothers and infants requires teaching from the earliest encounters. In 1996, federal legislation was passed to require insurance companies allow the option of a 48-hour hospital length of stay after vaginal birth and a 4-day length of stay after cesarean birth. Discharge may be earlier if deemed appropriate, after discussion between the physician or midwife and the patient. Although it is not required by federal law, many states mandate prompt follow-up for early discharge in the patient's home, an office, or a clinic. Some third-party payers voluntarily cover home visits for mothers who opt for earlier discharge because of the lower total cost for the home visit plus a short hospital length of stay. Concerns about early discharge. Although advantages of early discharge include prompt ambulation and reduced risk for hospital-acquired infection, concerns exist for new mothers and their families. Women may be exhausted from a long labor or complicated birth and unable to absorb all the information nurses attempt to teach before discharge. Once home, many new mothers also must care for other children. Nurses may detect early signs of maternal or infant complications that may not be evident to parents while in the healthcare facility. Parents at home may not recognize the development of a serious maternal or neonatal infection or jaundice, and care may be delayed until the illness has become severe. The ethical and legal implications of sending a mother home before she is ready to adequately care for herself and her newborn are very real concerns for nurses who should balance cost constraints with patient needs. Similar problems may occur in the older woman who must care for herself after an inpatient or outpatient procedure. Sedating drugs given for a procedure may have prolonged effects, especially for older adults. Although the older woman may appear to understand all instructions and sign papers indicating her understanding, she may not remember what she was taught after returning home. It is ideal for a trusted friend or family member to be taught with the patient and for printed or online instructions in simple language to be provided. Follow-up phone calls or visits are often scheduled to reevaluate the healing process after a procedure. Methods to deal with short lengths of stay. Teaching begins at admission. Self-care during pregnancy or in women's health begins at first encounter. Most teaching should occur during pregnancy when the mother's physical needs do not interfere with her ability to comprehend the new knowledge. In the facility, careful documentation and notification of the primary care provider are essential so patients are not discharged inappropriately if abnormal findings develop. Self-care and infant care discharge instructions should be explained to the woman and her support person. A printed form signed by both the patient and the nurse is placed in the chart, with a copy given to the woman for later reference in self-care and care of the baby. Other methods for follow-up, such as home visits, phone calls, and return visits to the birth facility for nursing assessments after discharge, may identify complications early when they can be addressed most effectively. Nursing follow-up by phone calls is the least expensive of post-discharge methods. However, the nurse does not see or physically examine the patient or her infant, and specific protocols and procedures should be in place for nursing actions that should be taken if a potential problem is identified during the call. Documentation should be kept for follow-up phone calls. Any instructions given to the patient, recommended actions if problems arise, if a minor problem does not improve, or if a problem worsens, during the phone call should be documented. And that is it for Chapter 2.